Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Listen, one of the things about doing Washington Gun Law is I so routinely have to spread bad news. However, today is going to be a rare exception because I have some really good news. It comes out of the state of Texas. It has to do with a big punch to the mouth that ATF took, not on the pistol brace rule, which we've been spending a lot of time talking about, but let us not forget that ATF also rewrote rules about frames and receivers. In particular, unfinished frames and receivers are what you might call 80% lowers. Well, a court in Texas was not too impressed with that and has thrown the entire ATF rule on frames and receivers out. Let's get you all up to speed. This is big news, and I think there's even more to read into it, which is also equally positive. So today, let's spend a couple of minutes and talk about how a court just threw out ATF's rule on frames and receivers. Okay, Saturday morning, getting this recorded, had a chance to get through the opinion last night. It came out yesterday, Friday, June 30th. Kudos to the Firearms Policy Coalition, who once again spearheading the charge on this thing. Some fantastic work. The case, of course, is Vanderstock v. Garland. We've talked about Vanderstock v. Garland. This is a challenge to ATF Rule 2021R-05F, which, of course, is ATF's new rule on unfinished frames and receivers. And to put it in a nutshell, there was this weird scale out there somewhere where somewhere along the spectrum, ATF would themselves determine when a piece of material went from just raw material to close enough to be in a frame or receiver that ATF then feels that it could regulate it as if it were a firearm. The bottom line is that ATF was trying to regulate chunks of aluminum and other materials in the same fashion that they get to regulate completed firearms. Now, this case was argued before the United States District Court, Northern District of Texas in Dallas. The court has issued a summary judgment and vacatur on this, and I'm going to explain both of those in just a moment. But what it really means is that the court, without having to hear from both parties, they basically reviewed the rules, reviewed the applicable law, reviewed the memorandum, and said, you know what? Plaintiffs win. Plaintiffs win here. And then the remedy is vacatur, which is they have vacated the entire rule. Okay, now let's get right to it. The court, in issuing its ruling, started framing the issue right away as follows. This case presents the question of whether the federal government may lawfully regulate partially manufactured firearm components, related firearm products, and other tools and materials in keeping with the Gun Control Act of 1968. Because the court concludes that the government cannot regulate those items without violating federal law, the court holds that the government's recently enacted final rule, definition of frame or receiver, and identification of firearms is an unlawful agency action taken in excess of ATF's statutory jurisdiction. On this basis, the court vacates the final rule. And here's the thing. This court very wisely took an incredibly complicated issue with all sorts of moving parts and boiled it down to its most simplest of conclusions. Because the court said, hey, this is actually a really easy case to decide. It's really this simple. Congress said that ATF can regulate firearms. Firearms shockingly have a statutory definition. So do frames and receivers. Those were all shockingly passed by Congress. ATF gets to regulate what Congress has said they get to regulate, which is firearms and completed frames and receivers. They don't get to regulate chunks of aluminum. In tracing the sordid history that brought the court to this conclusion, the court stated, rather than merely updating the terminology, ATF decided to regulate partial frames and receivers. Under the new final rule, the term frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver part kit that is designed to or may readily be completed and assembled, restored, or otherwise converted to function as a frame or receiver. And because the court so succinctly found that, hey, listen, we get that ATF has a chance to regulate frames and receivers. We're not talking about frames and receivers, so this is an easy decision. This is summary judgment material. But what's a summary judgment? A summary judgment is when one party moves the court and says, hey, listen, even if you take all of the evidence in the light most favorable to the other side, and you look at the applicable law, you take a look at the applicable facts, we still win, and there's no reason for us even to have a trial. And that's exactly what the court agreed with here. As they put it, disputes arising under the APA are commonly resolved on summary judgment, where district courts sit as an appellate tribunal to decide legal questions on the basis of the administrative record. Summary judgment is proper where the court finds there are no genuine disputes of material fact and the movement is entitled to judgment as a matter of law. And of course, there were challenges being made here under the Administrative Procedural Act, that is the APA, saying, hey, listen, they've acted outside their statutory scope here. They've acted outside of any statutory or legislative authority that they've been granted, which is exactly what the court agreed. They agreed to it to such an extent that they granted a summary judgment as follows. Once a court determines the contested agency action falls short of the APA's substantive or procedural requirements, the reviewing court shall set aside the unlawful agency action. And so the court was quick to point out that, hey, listen, if we have a statutory solution to this problem and we have a constitutional solution to this problem, the court's duty is to first resolve it under the statutory analysis. And if the statutory analysis reaches a conclusion, we don't even need to get into the constitutional deficiencies of this rulemaking order. So in this case, there was no rulings as to the constitutionality of what ATF did. All of the rulings pertain to what happened within the confines of the APA, the Administrative Procedural Act. The court ruled, there exists an ordinary rule that a federal court should not decide federal constitutional questions where a dispositive non-constitutional ground is available. Thus, if a case raises both statutory and constitutional questions, the inquiry should focus initially on the statutory question. Because the court concludes that the ATF has clearly and without question acted in excess of its statutory authority, and that this claim is dispositive, the court declines to address the constitutional questions presented. In reaching the final conclusion then, in favor of the plaintiffs, and striking this rule down, the court ruled, as they argued at the preliminary injunction stage, plaintiffs maintain that the final rule exceeds ATF's statutory authority in two primary ways. First, they argue that the ATF rule expands ATF's authority over parts that may be readily converted into frames or receivers when Congress limited ATF's authority to frames or receivers as such. Second, they argue that the final rule unlawfully treats component parts of a weapon in the aggregate, i.e. weapon part kits, as the equivalent of a firearm. The court agrees with plaintiffs. Basic principles of statutory interpretation decide this case. And for all of the things and all the legal mumbo jumbo that we geek out on all the time here at this channel, what this case really came down to was simple, plain English, as the court put it. Because Congress did not define frame or receiver, the words received their ordinary meaning. Contrary to defendant's assertion, in an interpretive dispute over a statutory term's meanings, the court does not simply leave the precise definition of that term to the discretion of the expertise of the ATF. The court went on to further state, as this court has previously discussed, the definition of firearm in the Gun Control Act does not cover all firearm parts. It covers specifically the frame or receiver of any such weapon that Congress defined as a firearm. And that which may become or may be converted to a functional receiver is not itself a receiver. Congress could have included a firearm parts that may be readily converted to frames or receivers, as it did with weapons that may be readily converted to fire projectiles, but it omitted that language when talking about frames and receivers. When Congress includes particular language in one section of a statute, but then omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. Now, in addition to all of that good news, there is another ruling in here, essentially that a weapon parts kit is not a firearm and cannot be regulated by ATF. Parts to a firearm cannot be regulated by ATF. Where else have we seen ATF regulate parts to firearms. Not like that would ever happen. But this has far-reaching implications, not only for the pistol brace rule, but some of the enforcement we've seen on forced reset triggers, and again on wide open triggers, and other component parts that we have seen the ATF come down on lately. As the court put it, as this court previously concluded, ATF has no general authority to regulate weapon parts. When Congress enacted the Gun Control Act, it replaced the FFA that authorized regulation of any parts of a firearm. In proposing the new regulation, defendants even acknowledged as much. Instead, under the Gun Control Act, the only firearm parts that fall under ATF's purview are the frame or receiver of any such weapon that Congress defined as a firearm. Think about that and how that applies to ATF's gross overreach now as it relates to firearms with attached stabilizing braces. Now, as we know, temporary injunctive relief was granted to the named plaintiffs and the people doing business with them. The remedy here, now that the court has granted summary judgment, is vacatur, which is a fancy Latin way of saying, hey, we're taking the rule and we're throwing it in the dumpster. This rule is hereby thrown out. It ends, it's done, we're over with it. As the court put it, the proper remedy for finding that an agency has exceeded its statutory jurisdiction is vacatur of the unlawful agency action. Whether remand without vacatur is the appropriate remedy turns on two factors. One, the seriousness of the deficiencies of the action, that is, how likely is it that the agency will be able to justify its decision on remand, and two, the disruptive consequences of vacatur. Vacatur is appropriate given the court's conclusion that the ATF has exceeded its statutory authority. All illegitimate agency action is void ab initio and therefore cannot be remanded as there is nothing for the agency to justify. So, I know this is a little bit longer video than normal, but there was a lot of good stuff in there and we wanted to get you up to speed. We're going to put links down below for the entire opinion so that you can read it yourself. The case, once again, is Vanderstock v. Garland. It's a case we talked about before. Kudos to the Firearms Policy Coalition. They spearheaded the charge here. Once again, have completely knocked it out of the park. We're going to put links down below for them in case you want to show them some love. Now, in the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is also down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.